Hello, hello. Let me lower this music. Or at least lower it in my headphones so I could hear what the fuck I'm saying. My name is Cut the Mic. Today is Friday. I'm coming to you live from New York City. Hello, Lucas. Welcome back. We no video gaming today. You won't have to suffer through me trying to do puzzles in Breath of the Wild. But you'll appreciate this story, and welcome anyone who's here, people that are not here that may watch the VOD. And to Lucas. Hello, Lucas. I was riding my bike today and I fell. I wiped out. Just fucking ate shit. May or may not have torn an ACL. You know, we'll never find out because I won't go to the doctor. But that's been my day so far. What are you sending me? Hey guys. Is that a Twitch like global emoji? Or is that not specific to someone? It's quite a weird emoji. All right, today I wanted to talk some legal news. Supreme Court had some pretty shitty decisions come down. Okay, hey guys, hello Lucas. Had some pretty shitty decisions come down the past few days. Wanted to talk about them a bit. One of them I am fairly familiar with, and wrote a paper about. Let's see if I can remember what the fuck I wrote about, but the other one is terrible as well, and it is stacked with some rather funny characters. So, oh, it worked beautifully. Okay. Sometimes it gives me issues. All right. We're going to start off with... I need to do a better job of organizing these. We're going to start off with Nestle US versus Dev. So this is the case where Nestle USA has been using enslaved children to farm their cocoa for the lovely hot chocolates that you might be drinking, or the the Nesquik, get your Nesquik fucking bottle of chocolate milk. That Nesquik bunny has been enslaving children. But what I want to focus on is this man right here, this man Neil Katyal, who argued for Nestle. And defended their practices. Oh, that's a good one. I didn't open that link. Defended their practices in the Supreme Court, and was ultimately successful. And successfully argued, and there was a 8-1 decision in which all but Justice Alito concurred. And I'll talk about that a bit later, but I think you'll find it interesting, the politics, and I think if you think a little bit about Alito, it's not too far off for him to dissent in this type of case. So before we get into the actual case, I just want to give you a little background on Neil Katyal. So Neil, obviously won a huge case arguing in front of the Supreme Court. Nowhere does he mention on his timeline nothing about the case he just won. He does mention the Affordable Care Act case, which we're not going to cover because I'm not very strong on that area of the law. But so here's Neil. He works for Hogan Lovells, which we could do a little research on them as well. Hogan Lovells is, I believe, where Justice Roberts hails from. They're a big appellate firm. Only 2,500 lawyers, but they're a big appellate firm. Argues a lot in front of the Supreme Court. Let's see. Current attorneys. Former. Okay. Yeah, John Roberts. Okay. Right there. John Roberts also worked here and obviously do a lot of appellate work, and their appellate work is defending largely corporations. Yep, here we go. Intellectual property. They're a big corporate firm. So it's natural that Neil, who was the acting Solicitor General for the U.S., has been a professor, has argued numerous cases, one of the highest case counts of any practicing attorney, arguing in front of the Supreme Court. Resistance warrior. If we go to Neil's website, first of all, we'll go back to this. It's fantastic TED Talks that Neil puts on. But he's just like the ultimate resistance grifter. Okay? Who wrote a book, No One is Above the Law. This belief is as American as freedom of speech and turkey on Thanksgiving. Held sacred by Democrats and Republicans alike, but as celebrated Supreme Court lawyer and former acting Solicitor General Neil Katyal argues in Impeach, if President Trump is not held accountable for repeatedly asking foreign powers to interfere in the 2020 presidential election, this could very well mark the end of our democracy. To quote President George Washington's farewell address, foreign influence is one of the most baneful foes of a Republican government. Impeachment should always be our last resort, explains Katyal, but our founders, our principles, and our Constitution leaves us with no choice but to impeach President Trump before it is too late. So this is the type of bullshit, bootlicking, uncritical analysis of what is going on and how we need to uphold our founders, our principles, and our Constitution. So is he a good or a bad guy? Neil's a bad guy, Lucas. Neil's a terrible person. He argued in front of the Supreme Court that Nestle, who makes your chocolate milk, so that you eat with your tendies at lunch, your Nesquik chocolate milk. He said, it's cool that they enslave children to mine their cocoa. So he is very uncritical, like most establishment type liberals are. Yeah. Can you imagine, Lucas? Nestle, where you get your fucking your chalky milk. They're enslaving children. And Neil, this wonderful man here, he defended them in front of the Supreme Court. And the Supreme Court, in an 8-1 decision, said, yeah, sure, that's fine. A little child labor is okay. Oh, that's cool. I could do that. Sorry, I'm moving my screen around. Lucas, I became a real streamer the other day when I put a third monitor in. So, this is the big time here. You're getting in on the ground floor. Okay. Yeah, so Neil, who's, again, acting Solicitor General, is he's a Merrick Garland type. when Merrick Garland was first sold as the moderate in 2015, 2016. So Merrick Garland sold as this moderate. Neil Cottrell's kind of like that same type, that same mold. But I guess even our politics amongst Republicans and Democrats have kind of shifted, and he's seen a little bit more demonized by the Republicans, even though most of his views are the same. So, some funny tweets. Neil Cottrell loves children. He loves them so much that he does not want them to be denied the opportunity to work in a mine. Get out of here. All right, so let's quickly go to... Oh, yes. Where'd you go? Ah, found it. Okay. So this is the decision. I thought cocoa was from a tree. It is from a tree, and children pick it off the tree, and then it gets ground up and it gets put in your chalky milk. And this man, Neil Cottrell, said, "Hey, Supreme Court, you can't hold this company liable for enslaving these children. If they were individuals, you could, but once you create a corporate entity, that notion goes out the window." And under the Alien Tort Statute, which is the crux of this case, and we get into saying that the Alien Tort Statute is a fucking mess, but we can't hold a foreign corporation liable for things that they do abroad, or even an American corporation liable for things that they do abroad. Okay. So I'll give the background here, and it says respondents are 6 individuals from Mali who allege that they were trafficked into Ivory Coast as child slaves to produce coca. U.S.-based companies Nestle USA and Cargill Inc. do not own or operate cocoa farms in the Ivory Coast. This is going to be important because this will be something that they hide behind. But they do buy cocoa from farms located there and provide those farms with technical and financial resources. Respondents sued Nestle, Cargill, and others under the Alien Tort Statute, which provides federal courts jurisdiction to hear claims brought by an alien for a tort only committed in violation of the laws of nations or the Treaty of the United States. So we're getting into international law, and particularly international human rights law. Okay. Before we do that, though, I don't know why I'm broadcasting in 720. I'm confused. What is an alien tort? So a tort is a civil... So that's what you need to understand first. A tort is a civil case. So you slip and fall at Home Depot because they have a wet floor because someone mopped. They didn't put the wet floor sign. So Home Depot is then liable for a tort, meaning they could be on the hook legally and financially for the injuries caused by the person. So it's not criminal law, it's civil law. Oh, I put the music back on. Good. And so an alien, we use in America the term alien to define a non-citizen of the United States. So this is saying here, and we could go to the actual statute to understand it, but in order for the federal courts to have jurisdiction, so in order for them to be able to hear the case and adjudicate it or rule on the matter, that they have jurisdiction, and there's a bunch of obstacles in order to get you there. But one of them, specific for the Alien Tort Statute, would be that the action that was committed. So they have jurisdiction to hear claims brought by an alien. So an alien is the one injured for a tort. So as opposed to criminal. So there's no criminal action here. It's only tort. Committed in violation of the laws of nations or treaties of the United States. So international law is weird and has different, I'd say, structures, hierarchies, and tiers to them. So essentially, treaty is straightforward. It's a treaty that the United States has signed onto and ratified, either through a self-actuating treaty or it's passed through bicameralism and then presentment. So whether it's the executive or whoever has the jurisdiction to make the treaty, it's signed by that person, and then the other branches of government may need to verify the treaty and pass it into actual law. Laws of nations is a little bit more difficult in that it's more ambiguous. There's different laws created through custom. So for instance, if 160 of 180 or so nations are forbidding child slavery, then you could say, okay, that's a law of nations, because generally, through custom, most of the known world is abiding by or prohibiting this practice, so we'll follow along with it. But before we do that, I need to fix this. And 20, 1080. Done. Okay, are we broadcasting in 1080 now is the question. We should be. Don't tell me I have to close Streamlabs for that effect. Take place. That's fucking annoying. Alright, whatever, I'll figure it out later. Alright. Yeah, I'm in law school right now. I graduate next year, and I work in the legal field, and have for a while. So I'm not a lawyer yet, but at least well versed in it. And think that more people need to understand what's going on in the law and understand it from a more lay perspective. So here I am. Okay, so Nestle and the other shit corporations say that... Oh, okay, I'm sorry. The 6 individuals from Mali allege, under the Alien Torts Statute, that the arrangement of, not owning or operating the cocoa farms, but at least providing financial resources and technical resources, that arrangement aids and abets the child slavery. So, it helps the child slavery is what this means, essentially. And because respondents' injuries occurred overseas, and the only domestic conduct alleged by respondents was general corporate activity, so none of the direct actions of, and this is probably what's going to get into the actual holding of the case, they weren't doing any actions, Nestle and Cargill, to like promote this child slavery, is what I believe the court is going to argue. And the only thing that they were doing was general corporate activity and like unaware of the child slavery. District Court dismissed the suit as impermissible extraterritorial application of the ATS. So this is an important case here. This is one of the, maybe I'll pull it up. So I can remember what's going on here. So this case, okay, 2012 case that Dutch, British, and Nigerian oil companies were exploiting citizens of Nigeria. Plaintiffs claim that the Royal Dutch Shell compelled Shell Nigeria, its Nigerian subsidiary, in cooperation with the Nigerian government in a brutal crushing of peaceful resistance to aggressive oil development. So they sought damages under the ATS. Argued that the customary international law, so that's what I was talking about earlier, itself provides the rules to decide whether conduct violates the law of nations where non-state actors are alleged to have committed the wrong in question. So one of the issues is it's not a state acting here, it's a corporation. Wow, I'm getting ads to donate to Juneteenth, and I'm sure that's like from fucking like Target or some shit. All right. Second, they contended that no norm has ever existed between nations that opposes liability upon corporate actors. Okay, I just want the Supreme Court's decision because I need to brush up on this. And so the Supreme Court in this case held that the presumption against extraterritoriality applies to claims under the ATS, and nothing in the statute rebuts that presumption. Court, in an opinion joined by 5 justices, held the presumption against extraterritoriality applies to claims under the... Okay. So, Supreme Court operates under this presumption against extraterritoriality, meaning that essentially they're going to adjudicate actions within the bounds of the United States, and they're not going to expand their jurisdiction to areas with, beyond the physical geographical borders of the United States and our various, I guess, territories. So what they're saying is essentially this is a limiting principle that is going to prevent people limiting principle that's going to prevent the Supreme Court or other federal courts is just going to give them a cop out to say, like, we don't need to look into this. We can't adjudicate here. It's one of their many cop outs, and usually limiting principles tend to be that. And another one that's famously or infamously deployed is political question. So essentially, when Supreme Court justices don't want to look into something, they think it's gonna hurt their legitimacy, may create too many enemies, is too nuanced of a question that they may not be able to touch on it or do it justice, or think that they won't do it justice. Justice meaning like not actual justice, but justice within their political ends to continue their legitimacy as like this apolitical body. So this is just another area there. So okay. So apparently, essentially Roberts says that this presumption normally only applies to merits questions. So not the jurisdiction. So whether there's an actual conflict, there's an actual controversy, the presumption against extraterritoriality is going to apply. The Alien Tort Statute is strictly jurisdictional. It's just giving them the means to take questions so this is like an entry. This is the first threshold you have to meet, and then the merits will come after. And he's just saying that he basically cops out as to another political question, and that he doesn't want to interfere with foreign policy, and that's not the judiciary's job, and that is something for the executive to handle. So they're kicking it there. So no back to Neal. And so the Ninth Circuit held that respondents had pled a domestic application prior to Coble because the corporation's major operational decisions originated in the United States. Supreme Court reverses and remands it. And remands it means they just send it down to the lower court to rehear it. So Thomas delivers the opinion. And we're going to ignore the syllabus and get to the actual opinion. Just the text is much bigger, and we'll skim through this. All right. Alien Tort Statute gives federal courts jurisdiction. We already talked about that. They're just citing a bunch of shit. Okay. According to the operative complaint, Ivory Coast, West African country, major global cocoa supplier. Okay, we discussed that. We're going to skim through this. You get to, after a while, you learn how easily you could skim through this shit. Okay, so here is giving a little discussion of Neal's argument. And this is what they agree with. Our precedents, Thomas writes, reflect a two-step framework for analyzing extraterritoriality issues. First, we presume that a statute applies only domestically, and we ask whether the statute gives a clear affirmative indication that rebuts this presumption. That was the presumption of extraterritoriality that we talked about under Coble just a second ago. For the ATS, Coble answered that question in the negative. Okay, so this is now we're applying it to jurisdictional questions. Although we have interpreted its purely jurisdictional text to implicitly enable courts to create causes of action, the ATS does not expressly regulate conduct at all, much less evince a clear indication of extraterritoriality. Courts thus cannot give extraterritorial reach to any cause of action judicially created under the ATS. That one's a little confusing to me. Second, where the statute, as here, does not apply extraterritorially, plaintiffs must establish. Wow. Extraterritoriality really is a tongue twister and is giving me some issues. Oh, I just realized I don't have all my lights on. Second, where the statute, as here, does not apply extraterritorially, plaintiffs must establish that the conduct relevant to the statute's focus occurred in the United States. Okay. So we're not giving extraterritorial reach to the actions in the other country. So if it just happens in the other country and it's simply a US based actor that's doing it in the other country to non-US citizens, shit out of luck, right? Unless you could establish that the relevant conduct of the statute's focus occurred in the United States. So here is where I'm saying that you run into the issue that the court is saying, and Neil is arguing, and this is a argument that works on many different levels in the corporate world and has many at least from the cases you read, you see this used quite a bit to skirt responsibility and liability, and saying that the actions in the United States were so minimal because they were just like a few executives in a boardroom deciding whether or not to use these companies to pick their coca. That's so minimal that can't be the action that we're trying to regulate. The conduct that's relevant to the statute's focus. That's absurd, is what they say. Which really what they're saying itself is absurd. So let's see if we could find it here. All of that alleged conduct occurred overseas in this suit. So aiding and abetting forced labor overseas is what they're suing for. Okay. Arguing that aiding and abetting is not even a tort, but merely a secondary liability for a tort, petitioners in the United States contend that the conduct relevant to the ATS's focus is the conduct that directly caused the injury. So they're saying, this is like saying that the Nazi soldiers are more culpable than those Nazi generals that made the decision to exterminate people. This is an absurd argument. Absolutely absurd. And is always going to shield corporate actors. I think there's somewhere here. I have the tweet. Yeah, here it is. My dad, a practicing attorney for 40 plus years, read the Nestle cargo rulings and goes, "This is a blueprint for how to get away with slavery." Up there with Dred Scott and Korematsu. So here we have another anti-canon case. Cottrell explicitly argued that the sole distinguishing fact was that Nestle is a corporation and agreed that an individual could be held liable under the exact same facts. So just do it in corporate form. All right, so this is a screenshot from the transcript. That's the word I was looking for. The transcript of Cottrell's oral arguments in front of the Supreme Court, and this is Kavanaugh speaking, or asking the question. He says, "Good morning, Mr. Cottrell. The Alien Tort Statute was once an engine of international human rights protection. Your position, however, would allow suits by aliens only against individuals, as you have said, and only for torts international law recognized that occurred in the United States." Professor Coe's amicus brief. So people are either asked by the petitioners or respondents or have certain institutional stake and can write amicus briefs. It just means friend. It's amici curiae, friend of the court briefs. So that's what's going on here. I need to figure out a better mic position. Sorry. Need to add ADD to the tags. All right. Says that your position would gut the statute. So why would we do that? So Cottrell's response. Well, I really feel like that's some overheated rhetoric. Okay, so that's Neil Cottrell. So we're going to keep reading. So we're saying that it's a secondary liability for a tort. So they're saying the conduct relevant to the... Yeah? Yes, Lucas? All that alleged conduct occurred overseas in this suit. So all the conduct that is directly relating to the injury, so the conduct that's directly related to the child enslavement, Cottrell and the court are saying that was the actual contractors or overseers of those the children that were enslaved, so the child slavers, and not Nestle, because they were operating out of the U.S. Essentially, like, how could they know? Okay. And I think this is important to highlight. That sometimes Thomas just is an idiot. And is just mask off without even realizing it. The United States also argues that the focus inquiry is beside the point. Courts should not create an aiding and abetting cause of action under the ATS at all. This is just giving a corporate shield. This is no different than the New York State corporate shield that Cuomo pushed through during the pandemic to protect hospitals and nursing homes. All this is going to do is push off the liability to the people on the ground and not the corporate actors making the high level decisions. Like feeding into and validating the slave labor, the child slave labor that these people are using and Nestle is exploiting. Okay, so respondents argued that aiding and abetting is a freestanding tort, so not secondary liability, and the courts may create a private right of action to enforce it under the ATS. They also contend that the focus of the ATS is conduct that violates an international law, that aiding and abetting forced labor is a violation of international law, and that domestic conduct can aid and abet. So I don't get... Thomas, you're such a poor writer. Such a terrible writer. But people love his laugh and smile. For their part, respondents argue that aiding and abetting is a freestanding tort and that courts may create a private right of action to enforce it under the ATS. Even if we resolved all these disputes in respondents' favor, their complaint would impermissibly seek extraterritorial application of the ATS. Nearly all the conduct that they say aided and abetted forced labor, providing training, fertilizer, tools, and cash to overseas farms, occurred in the Ivory Coast. Ninth Circuit nonetheless let the suit proceed because respondents pleaded as a general matter that every major operational decision by both companies is made in or approved in the United States. But allegations of general corporate activity, like decision making, cannot alone establish domestic application of the ATS. Wow. I'm glad I'm reading this on stream. I hadn't read it earlier, and it is worse than I thought. Pleading general corporate activity is no better. As we made clear in COBOL, plaintiff does not plead facts sufficient to support domestic application of the ATS simply by alleging mere corporate presence of a defendant. So, in COBOL, they're saying just mere corporate presence, operating, like having a corporate presence operating in that area, does not overcome the presumption of extraterritoriality, presumption against extraterritoriality. Now he's saying pleading general corporate activity is no better. But like, Thomas, here, this isn't general corporate activity. Okay? It's specific corporate activity that is providing training, fertilizer, tools, and cash to these farms. So then what are they turning around and doing with that cash? Who is then using those tools and fertilizer? Thomas needs a lot of new things. Clarence Thomas is a black man that is against affirmative action. Like, that's essentially all you need to know about him. And his wife is a avid QAnon supporter. Where was I? Okay. So that's more than general corporate activity. Okay? That's specific. You're making the decision to use these farms. And you can't plead ignorance that you didn't know they were using children as slaves. That's a bullshit cop-out. You know? Yeah, that's the conspiracy thing, QAnon. Some of this shit. Alright. So it fails for another reason. He says, does not require parsing allegations, cannot create a cause of action that would let them sue petitioners. Such a fucking bad writer. That job belongs to Congress, not the federal judiciary. So they also, like, you know, on top of like the political question, and this is essentially another version of political question without saying political question. It's, you know, we don't want to be an activist judiciary. We're not going to legislate from the bench. This is particularly important when it's coming from someone like Thomas, who very much does judicial activism when it favors his agenda or the conservative legal agenda writ large. Okay, we're not going to read through the history and the precedent. That's really not important because all of it is just bullshit justification to say that child slavery or enslaved children, when corporations enslave children, it's okay. And in all this, just even skimming it, you could tell it's just that notion, you know, might doubt a judicial decision to create a cause of action. Language like this. Where is it? Here's another great one. Although specific foreign policy concerns may vary from case to case, our precedents are clear that creating a cause of action to enforce international law beyond 3 historical torts invariably gives rise to foreign policy concerns. I forget what the 3 historical torts are. Foreign policy concerns are inherent in ATS litigation because the political branches, not the judiciary, have the responsibility and institutional capacity to weigh foreign policy concerns. There will always be a sound reason for courts not to create a cause of action for violation of international law, other than perhaps for those 3 torts that are well established in 1789. So let's go back. So again, we're just restricting it to the fucking founding. Originally passed as part of the Judiciary Act of 1789, the ATS provided jurisdiction to hear claims brought in an alien or for a tort only committed in violation of the law of nations or a treaty of the United States. But the statute on its own does not empower aliens to sue. We have been clear that the ATS is a jurisdictional statute, creating no new causes of action. So again, no, it's just jurisdiction, not cause of action. Aliens harmed by a violation of international law must rely on legislative and executive remedies, not judicial remedies, unless provided with an independent cause of action. In more than 200 years, Congress has established just one: the Torture Victim Protection Act of 1991. The act creates a private right of action for victims of torture and extrajudicial killings. In so we assume that the first Congress, which enacted the ATS, believed that federal courts under general common law would recognize private causes of action for certain torts in violation of the law of nations. So he wants us to go back, essentially, to what the law of nations were in 1789. Denied the... Okay. This case is just fucking bane of my existence. And honestly, I would like to do a critical analysis of Erie and its effect. It's really more of a what if type question. What if we had the general federal common law, and judges were empowered to essentially legislate from the bench, and it wasn't a bad thing. And honestly, it's interesting to me, like the height of New Deal, we're getting this case shut down. I guess earlier than New Deal. All right, 3 historical torts: violation of safe conducts, infringements on the rights of ambassadors, and piracy. And this is literally piracy, like fucking Captain Jack Sparrow piracy. That's it. This is like fucking yo-ho and a bottle of rum. Pirates is what they're thinking. And there have been cases where piracy has been extended when it fits, again, the conservative and like centrist legal agenda. Infringements of rights of ambassadors is like, I feel like that's easy. Violation of safe conducts, I'm not sure what that means. And I feel like just on its face, not knowing what the actual like legal precedential definition is, violation of safe conducts, I would say that child slavery is not a safe conduct. And how could you apply, how could you apply a law from 1789, the height of American slavery? Okay, how can you apply a law from then when we thought slavery was okay to analyze actions of slavery in 2021? Right? But that's how lawyers think. Lawyers have a perverted mind that just doesn't make sense. And they try to indoctrinate you into that perverted mind palace that they have, and it takes all of your might to stop them from taking over your mind. Where was I? Okay. Two-step test that they must satisfy. Plaintiff must establish the defendant violated a norm that is specific, universal, and obligatory under international law. I think amongst the like civilized first world countries, I'm pretty sure that we've kind of decided at a normative basis that we don't enslave children. Do we is it good to enslave? No, we don't enslave children. I'd say that's a fucking norm. That norm must be defined with a specificity comparable to the 3 international torts known in 1789. All right. We used to? Yeah, but that's what I'm saying. Like now, it's the norms now. And that's what's crazy. So I was just saying, like, you're using 1789 law to analyze something that happened today. And you should be analyzing it under where was it? Today's norms. Because of course, if you analyze something that happened today using a 1798 law and the construction of it in 1798, of course, the norms that you're gonna, if you apply the 1798 norms, of course slavery is okay. But, we're in 2021 now. And these norms, okay, must define with a specific specificity comparable to the 3 international torts known in 1798. Well, it doesn't seem like, I won't scroll up again because I'm going to keep getting lost, but it doesn't seem like safe conducts or against safe conducts, whatever it was very specific. Piracy, I would say a law against piracy or a norm against piracy is just as specific as a norm against child enslavement. And I would actually argue a norm against child enslavement is much more specific than piracy. Especially today. Especially when piracy can mean different things. Okay, so they're saying second part of the test. So first you have to say there's a norm that's specific, universal, and obligatory. All right. Then from there, you have to say the plaintiff must show courts should exercise judicial discretion to create a cause of action rather than defer to Congress. So, what they're saying is they're taking a formalistic legal approach here. And what they're saying is because it's an aiding and abetting, the cause of action, the aiding and abetting child slavery, they shouldn't exercise judicial discretion, instead should defer to Congress to make that new cause of action. But when they do that, what they're really doing is taking that cause of action out of context of what the harm of that action was, or what the result of that action was. And the result of that aiding and abetting was U.S. corporations providing resources and giving the means to farmers in the Ivory Coast to continue employing slave labor and exploiting children of that area. So it really comes down to a formalistic legal interpretation to allow slavery to continue. And that's the name of the game for conservative justices. So here's some more of his analysis, and we're going to kind of skip through it because I want to speed through this a bit. Oh, okay. All right. I want to read Alito's dissent, and there's not much more of the initial opinion. I won't read the concurrence. Regardless of whether respondents have satisfied the first step of the SOSA test, it is clear that they have not satisfied the second. Okay. So, not even saying whether or not aiding and abetting child slavery is... This is... Did I fuck up my chair? I fucked up the settings, whatever. This is one of my favorite conservative moves. Okay? You could decide whether they satisfied the first step. You know? You could say that aiding and abetting child slavery is bad. It's a specific... Where does he say? It needs to be... It violates a norm that is specific, universal, and obligatory. Okay? You could say that. That'd be a big statement to make. It'd be some virtue signaling bullshit, but coming from the Supreme Court, it's either gonna make waves or you know, everyone will be like, yeah, okay, that sounds right. He's saying it doesn't even matter. We're not even gonna fucking discuss that because we know that they haven't satisfied the second. So we had to have it's a you know, a 2-step test. You have to do the first step to get to the second one. But they're going to say, all right, we're going to skip over it because we looked to the second one first and we said they didn't satisfy the second one. So we shouldn't even bother with the first one, which is absolute backwards logic. Doesn't make sense. And these are supposed to be the smartest legal minds that the U.S. has to offer. Our decisions since SOSA, as well as congressional activity, compel the conclusion that federal courts should not recognize private rights of actions for the violation of international law beyond the 3 historical torts identified in SOSA. So, in here, he's not saying that it's almost as if he's not leaving room for other causes of action to be added. Our decisions since SOSA, as well as congressional activity, compel the conclusion that federal courts should not recognize private rights of action for violation of international law beyond the 3 historical torts identified in SOSA. We recently identified a sound reason to think Congress might doubt a judicial decision to create a cause of action that would enforce torts beyond those 3. Creating a cause of action under the ATS inherently raises foreign policy concerns. And here we go. He falls back on this. This suit illustrates the point. For the allegations were here implicate a partnership between the Department of Labor, petitioners, and the government of the Ivory Coast. Under that partnership, petitioners provide material resources and training to cocoa farmers in the Ivory Coast. Companies or individuals may be less likely to engage in intergovernmental efforts if they fear those activities will subject them to private suits. I'm going to read that one again. Companies or individuals may be less likely to engage in intergovernmental efforts if they fear those activities will subject them to private suits. So companies are going to be less likely to engage in child slavery if we subject them to private suits for enslaving children. So, Thomas, you're saying that you don't want to deter that type of activity? You're afraid that more companies might be sued? It's a little sus. Although specific foreign policy concerns may vary from case to case, our precedents are clear that creating a cause of action to enforce international law beyond 3 historical torts invariably gives rise to foreign policy concerns. Because the political branches, not the judiciary, have the responsibility and institutional capacity to weigh foreign policy concerns, there will always be a sound reason for courts not to create a cause of action for violation of international law, or then perhaps for those 3 torts that were well established in 1789. It's just absurd. Your brain is so perverted. Congressional activity independently provides a sound reason to conclude that Congress might doubt a judicially created cause of action. It is instructive to consider the changes Congress made to the remedies of the Trafficking Victims Protection Reauthorization Act of 2003, which imposes liabilities for offenses related to human trafficking. The initial text passed in 2000 imposed criminal liability for human trafficking. Okay. Congress later adopted a private right of action in 2003, allowing plaintiffs to sue the immediate perpetrator of human right. So here we go with the immediate perpetrator. So this is, again, individuals can be sued in civil court. The immediate perpetrator of a human trafficking violation can be sued in court. But if you're a corporation and you're only providing the resources and the means for that perpetrator to do the human trafficking, you get off scot-free. So, to human traffickers out there, simply create an LLC. Parody, please don't. That is not advice. This is no legal advice here, and I do not support human traffickers. But apparently, the Supreme Court of the United States, 8 of them believe that companies could enslave children. That's fine. This act highlights that there are many different ways to create a cause of action that would enforce developments in international law beyond the 3 historical torts identified in SOSA. Too many for courts to choose from when using the limited judicial discretion that SOSA recognizes. But chat, if we have more than 3 historical torts, the courts will be overburdened. We don't have enough discretion. Congress may well decide to create a cause of action against one category of defendants, but not another. Or it might make distinctions, as it did in the TVPRA, between direct and indirect liability. Congress settled on the current approach to private remedies against human trafficking only under its understanding of the problem evolved through years of studying how to best craft a response. Wow. This is like going after the fucking corner kid. Okay? Here's another one. Going after the corner kid, the watch kid, that's, that's taking your money before you go to the other guy in the car to get your drugs. Okay? That's like going after that kid instead of the fucking head of the cartel. Okay? Going after all the corner boys that are taking the fucking money, that's before the purchaser picks up their drugs. We're going to arrest all the corner boys. They are, that's the problem. The understanding of the problem evolved that it's the corner boys' fault. We're going to arrest them. We're going to have private actions against them. They're the ones that are enabling these overdoses because they're taking the money. And then they tell the user where to go, meaning which car to go to. So we're going to go after them instead of the cartel. So, that's the problem. The problem is the individual. Okay. It's always the individual. It's nothing systematic. Yeah, obviously, that corner boy, he's causing trouble, Lucas. Lucas, don't become a corner boy. All right. Don't do that to me. They'll come after you. And I can't have that. You're my only viewer. Congress settled on the current approach to private remedies against human trafficking only after its understanding. I read that. Judicial role is to resolve cases and controversies. It's important. That's another one of their cop-outs, which typically present only the perspectives of the parties. Judiciary does not have the institutional capacity. This is straight from, oh no, it's from Jesner. Okay. Well, Jesner's citing Coble because this is the same stuff. They don't have the institutional capacity to weigh the foreign policy. That's better left for the executive or Congress. We then decided Sosa, which remarked that there is no basis to suspect Congress had any examples in mind beyond the 3 torts when it enacted the ATS. We assumed that no development of law had yet precluded federal courts from recognizing causes of action not created by Congress. Nobody here has expressly asked us to revisit Sosa. Okay. Another fantastic move that they do. It is so annoying. When Thomas or the other chud Republican justices whenever they see a remedy to an issue, but it's not the explicit question asked by the petitioners, they won't look at it. So you didn't ask us. So it's like a mother saying, baby, you didn't cry for food, so I didn't feed you all day. You didn't ask, so I didn't fucking look into it. All right? However, when they see an issue that has not been asked, but that issue better aligns with their conservative values or their conservative legal agenda, they will undoubtedly look at that issue and decide on it, even if it's not what is asked by the petitioners. And I wish I could think. There's one particular case I'm thinking of. I can't think of the name at the moment. But precedents since Sosa have substantially narrowed the circumstances in which judicial discretion under the Sosa test is permitted. So saying like, all right, Sosa limited us and we've continued to limit ourselves because the court loves, chat, to limit their own power. But as to other torts, our precedents already made clear that there's always a sound reason to defer to Congress, so courts may not create a cause of action for these torts. Whether and to what extent defendants should be liable under the ATS for torts beyond the 3 historical torts identified in Sosa lies within the province of the legislative branch. So, like, the legislative branch that conservatives and, like, those conservative justices think don't do anything, and, obviously the conservatives are reactionary and are, why can't I think of the word? Obstructionists. We're just going to defer to the legislative branch. All right, so I don't need to read what these dinguses wrote. I don't care. Gorsuch. All right, this is what I'm interested in. It's so long. Sotomayor, why do you write so much? Oh my God. It's longer than the real opinion. And then Alito writes 2 pages. All right, we're going to read Alito, and then I'm going to skim Sotomayor's. I'm fucking pissed at her. Whatever. And I'll go into a little bit about Sotomayor. But Alito, diehard Catholic, idiot, world-renowned idiot. I did a few shrines. I did a lot of just opening up the map. I was just going to towers and opening them up. And Yeah, I didn't try to beat the Lionel or just or capture his, gather his arrows. I was just trying to like open up some of the map and do some like resource gathering and stuff. I did a lot of cooking. Because I need to get better with the gameplay. Where was that? Okay. Primary question presented in the 2 petitions filed in these cases. I would decide that question. And for reasons explained in part 1 of the courses, which I joined, I would. They fucking do this. They like all join different parts. So this is an 8-1 opinion, but like it's almost. They're all just fucking writing for their own egos. But in my view, we should not decide that question at this juncture. The extraterritorial application. It is tied to the question whether the plaintiff should be allowed to amend their complaint. Okay, so it's another fucking legal formalism. Specifically, the court must assume that contrary to the arguments set out in part 3. Okay, it's not even worth reading. Let's quickly look at how Kagan, Breyer, and Sotomayor, how they argue for child slavery being okay. Okay. I joined parts 1 and part 2 of the court's opinion because respondents have failed to allege a domestic application of the Alien Tort Statute. Their complaint must be dismissed. I do not, however, join Thomas's alternative path to that disposition, which would overrule Sosa. Yeah, okay. Sotomayor did a thing. Because 1... just his judgment of court and delivered the opinion of the court with respects to part 1 and 2, and an opinion with respect to part 3. Okay. Okay. 3 people agree with part 3. Part 3 is void. That's not precedent, or shouldn't be precedent, because I believe because there should be 4 against part 3. That's still Thomas. Yes. Part 1 is a 9-0 decision. This is a mess. This decision's a mess. Absolute mess. Concurring in part and concurring in judgment. This is a mess. This is such a messy case. Justice Thomas would limit the ATS's reach to only the 3, so that's part 3. The only 3 international laws. Torts are recognized in 1789. Gave federal courts cognizance of all causes where an alien sues for a tort only in violation of the law of nations or a treaty of the United States. I'm ending soon anyways, Lucas. I appreciate hanging around. Enjoy your birthday party. Yeah, these are wonderful humans. I'm going to finish reading up this section. I'm going to look through a few tweets and then I got to head off for the day anyways. Alright, the ATS does not list the torts that fall within its purview. Rather, the statute was enacted on the understanding that federal common law would provide a cause of action for the modest number of international law violations. This is what I'm saying, that what if we were allowed, the courts were allowed to make federal common law? It'd be so much better. 3 such torts, probably on the minds of the men that drafted it. Yeah. Honestly, it's not even worth reading the rest of Sotomayor's opinion because it's just doo-doo trash. Okay. Well, we're better off reading A-Lab's take on this. So he says, shh. Now, do we say that Sotomayor and other liberals supported child slavery by all voting for Nestle today? Of course not. And Nestle's lawyers, like Neil Katyal, obviously don't either. The cheap attacks on the court and thoughtful lawyers did not age well. SCOTUS blog is just caping for the Supreme Court. And there's this funny thing that I struggle with, in that the presiding norm in the legal world is a lawyer could represent. Yeah, I'm going to stream tomorrow and I'll play video games tomorrow. A lawyer could represent whoever they want. So, so they could defend whoever they want, represent whoever they want. And by doing that, they're not taking on their morals. So it's a way of looking at lawyers as like neutral third parties that are, they have a commitment and a duty to their client, but like that duty doesn't conflict with their personal held beliefs. So like the ACLU historically represented Nazis, things like that. So that's what they're trying to say here, is like Neil's not defending slavery. Like, he's just defending his client. He's just defending the corporation. And like, it's almost like the circular logic of like, the court said that it was okay. So like, now you can't say that he's defending slavery because the court said that it's not child slavery. Yeah? Okay. It's fucking insane. Read that one. Jay Willis, good one to another good Twitter account to read. The real question here is whether Neil Katyal, who as many of you know has argued more Supreme Court cases than any attorney of color, including Thurgood Marshall, gets to add the child slavery case a full win to his tally or just a courtesy half. Congrats, Neil Katyal. Yeah, here. So this is what I was saying. Vanessa Abai, pointed out perfectly. Will he do it? Will he tweet about his latest win? Stay tuned to find out. He fucking didn't. He fucking didn't. And because he's so ashamed. He knows he did a shit thing. He's a little fucking, he's got his tail between his legs. Thurgood Marshall was famously almost lynched doing civil rights work as a litigator. That this fancy clown takes filthy cases like this so he can run around claiming he beat Marshall's record for most Scottish arguments by a POC is so shameless and galling it hurts. Reply. He didn't do it. I don't know if this is satire, like if this is a joke. By God, he did it. Neil just won this case. Child slavery is now legal. Thanks, everyone. Okay. Oh, fuck you, Amy. We're not going to read your shit. we're gonna end on this high note of the only candidate to rank number 1 for the New York City election, and I am no joke, no cap, not fucking around here. This is my number 1 choice for mayor, Paperboy Prince for New York City mayor. All right. This dude here has to be satire. No. Paperboy Prince is running for mayor. He's the only one that you should be ranking number 1. Everyone else is terrible. This dude, look at him. He wants to defund the police. The other one. Oh, yeah. That tweet. Yeah, it has to be satire. Was it? I think I showed the picture I wanted to show. Oh, wow. I didn't read this. Diana Morales was the other progressive candidate that her campaign has fallen apart. Paperboy Prince says Diana Morales flaked on meeting with me like 3 different times after reaching out and asking me to collaborate. I really can't trust a mayor that can't keep their word. Like how you asked me to hang, then cancel the day before. No worries. I was watching it on my desktop, and there's a desktop delay too. I gotta check that out. And it shouldn't be that big of a delay. That my internet's good. I also had the settings on my streaming settings on 720. I thought I changed them, but it is not changing. But that's all I got for today, folks. And by folks, I mean Lucas. Enjoy your birthday party, Lucas. Be safe, have fun, be nice to everyone. And I will see you all tomorrow. Might be playing Mario Sunshine. Most likely we'll be playing Mario Sunshine tomorrow. Maybe throwing a little Breath of the Wild. But all right, everyone have a nice night, and we'll see you tomorrow. Bye-bye.